Okay, good evening, assalamu alaikum, and welcome to Aman Solicitors Ask Aman Livestream. This is the first one we are starting today. And just to give you a little bit about what we're going to do today. So a number of my colleagues from the office will be joining me on this live stream. On the screen at the moment, you've got Mr. Saad Saeed, who will be first up. Assalamu alaikum and good evening, Saad.
Wa alaikum assalam, Mr. Bashar. How are you?
Very well, thank you for joining me. Our colleague Adnan Mahmood and Raheel Latif will also be joining us in the live stream, and we're going to ask each of the solicitors to give us some basic information regarding an area they all selected. For the first one we've got is Saad Saeed. He will talk about employment law, and given what we have at the moment with regard to furlough and redundancy, so we're going to talk about the law of redundancy and how a firm should lawfully go through the process of redundancy. And if you as an employee are being made redundant, this is something for you to take note of, as it should be for the employee. So what we'll do now is we'll ask Saad to go through, in the next 5 minutes or so, the basic process. So Saad, if I'm an employer and I want to make you redundant, how do I do it? Sorry, I'm joking.
That's fine, not a problem. I mean, that's the question I get asked many, many times. But yes, Bashar, you're very right to say that employers and employees do need to know their rights, and they need to know what the correct procedure is, because obviously if things aren't done properly, this is what opens everybody up to legal claims in the tribunals and the courts and things like that, and it's something that people seek to avoid generally. So let's start off really with the definition of redundancy. So the definition of redundancy by law is when either one of three things happens. It's either when the business for which the purpose for which the business was created ceases or is expected to cease to carry on, or it could
give us an example of that, if you don't mind, just to explain. So a company going out of business, for example.
Yeah, exactly. Quite honestly, a company going out of business, because or it could be the work for which they've taken on a particular employee ceases to exist or is expected to cease to exist. So let's say, for example, I mean, we work in solicitors firms. Let's say we have 10 solicitors, but then you only need 5 because there's not enough work available. So then again, the type of work that is expected to carry on is ceasing or diminishing. That's also redundancy. Or whether business in the actual office you're carrying on ceases to exist or is expected to cease to exist. So if a company has, for example, 5 offices, maybe one in London, one in New York, one in Tokyo, let's say one in Manchester, and they no longer need the business in the office in Manchester, then that also satisfies the definition of redundancy. So redundancy is when one of these 3 situations happens, and importantly, it doesn't bite when the work actually diminishes. It comes into effect when there's an expectation that the actual work or business is going to diminish. That satisfies the definition of redundancy. Now, once the definition of redundancy is satisfied, then what every employer needs to do and make sure is that they follow a suitable and lawful and fair redundancy process.
Yeah.
Now, there are 3 stages, let's say three aspects to this process. The first is what we would call a consultation. So the employer has to carry out a consultation. Now, regarding the consultation, if an employer is going to be dismissing or thinking of dismissing less than 20 employees, that consultation really has to be an individual consultation with each employee. Okay. If it's going to be dismissing 20 people or more, then we move to what's called a collective consultation. And there's differences between the individual and collective consultation processes. We may go into the details of collective consultation.
So what does an employer have to do, just if I may come in? So does the employer have to notify everybody, look, this particular job is going to cease to exist, and therefore here are your rights for the redundancy process to kick off, time limits and things like that? Or is it simply completely unnecessary to communicate any of this to the employees?
No, it's very important to communicate things to the employees. So let's say, practically speaking, we would hope to see that in the first instance, when an employer thinks or decides that there is a redundancy situation coming up, they communicate this to all their employees and inform them to put them on notice, so to speak. if they're going to be making less than 20 people redundant, I would also expect the employer to have a meeting with each employee individually to outline the reasons why this has happened. Okay, and now then importantly, we move to the second aspect of the consultation process, which is they should offer each employee suitable or look for suitable alternative employment for them, because that is obviously an alternative to making the employee redundancy. And the whole point of
this is a necessary requirement that, sorry to interrupt, this is a necessary requirement when the redundancy process goes into motion, that anybody who's potentially going to be made redundant, they must look in the organization to see if an alternative position which is viable is available.
The quick answer to that question is yes. But before everybody out there starts jumping and thinking, okay, this has to happen in every case, no, it doesn't have to happen in every case. We take into account the size of the business and the size of the organization, and the steps that the employer has to take has to be what we call reasonable steps. So if we have a very, very small company where there may be only 3 or 4 employees, it may be reasonable for them not to offer any suitable alternative employment because there simply isn't any, because the business is too small.
Fair enough.
Contrast that with a multinational company with many, many offices, with many, many various positions, and they would, I would say, have to take reasonable steps to offer suitable alternative employment. And if they didn't within their own company, that could potentially be unreasonable. So it is a question of scale of the company and size of the organization as well.
That seems reasonable. I mean, so the process of redundancy has been activated, the consultation's taken place, and let's say you're the unlucky person or persons who've been told, look, sorry, John or Abdul or Dave, you're going to have to go. What are your rights to challenge that within the organization, first of all?
Yeah, so like I said, it's about this whole consultation process. So the third aspect, that brings me nicely onto the third aspect. The third aspect of all of this is that the whole process has to be fair. Okay, so from a point of view of the individual who's facing redundancy, they want to make sure that they are consulted with in a fair manner. They are told the right things. They want to make sure that they are reasonably and fairly offered suitable alternative employment. And that brings me on to how people are selected for redundancy. So as part of the process, the employer has to decide what group of people are to be made redundant. We call this the pool of people to be made redundant. So the criteria used to determine which pool of people are to be made redundant has to be fair. So as an individual, you can ask your employer to tell you what criteria were used to determine which pool of people were to be made redundant, and you can challenge that if you think it was unfair. Okay, if you think the criteria used were wrong. So let's give an example, practical example.
Excellent.
Some employers may base it entirely upon the person's punctuality record. Okay, so they'll say, the only thing we've considered is punctuality. The reason you've been selected is because your punctuality was the poorest out of all 100 people that we've considered. Okay, now in this day and age, if that was the only criteria used and punctuality was not an important factor in the overall place in the overall business, then you could say that is an unfair criteria used. Okay, I mean, we're talking a little bit basic here. In reality, more things are taken into account, like behavior, attendance records.
Okay, so all of the work. So they've looked at all the relevant criteria. You've got the little tap on the shoulder. Here's your notice. You're made redundant. What must you do internally before you go to any tribunal? Well, now, once the employer's made a decision to make a redundant, they obviously have to notify you in writing. Some employers will actually give an internal right of appeal. And if they do, usually you get 5 days to lodge that appeal. That is something that the individual can do, and they can try and challenge the decision to make them redundant by exercising that right of appeal. If they're not given that right of appeal, then the only alternative then is to consider a claim in the employment tribunal. Everybody who's been made redundant has 6 months to make a claim within the employment tribunal, but very, very importantly, before they think about that, they must contact ACAS and they must go through early conciliation. That's the Arbitration and Conciliation Service, right?
That's correct, yes. And without contacting ACAS, without going through the early conciliation process, you cannot make a claim to the employment tribunal. If you try to do that, it will just be rejected.
Excellent. Thanks for that. Well, so that's a very good introduction to redundancy. If you're just joining the live stream, we've just summarized the redundancy process. What an employer must do: you must be consulted. That consultation must be fair. And if the process concludes in you losing your job or being made redundant, then you have, if you're given a right of appeal, you'll take it. If not, you must go to the service known as ACAS, the Arbitration and Conciliation Service, and try and resolve the dispute there. If not, then you can go to the courts and you have 6 months to do so. If you know what you're doing, you can do it yourself. If not, seek competent professional advice. And just, it wouldn't be a legal live stream without a disclaimer. All of the information and the advice we're giving on this show is general in nature. You do not rely on it to litigate or carry out any legal action. You must take professional legal advice from somebody who's competent and qualified to give you that advice before you act in person. Just putting the disclaimer there for you. Next, we'll go to our colleague Adnan Mahmood. Adnan, Assalamu alaikum, good evening.
Alaikum salam. How are you?
I'm very well. Thank you very much for joining us. Now, you're going to share your thoughts about a naughty landlord and a poor businessman who got thrown out, and tell us the story.
Yeah. Well, this particular example is quite pertinent in the current climate with the COVID pandemic raging. What you've had is a lot of commercial landlords, a lot of commercial business owners are finding it difficult to operate their business, especially when the pandemic first hit. A lot of businesses couldn't afford to pay their rent. They couldn't afford to pay their business rates. They were really struggling. And even until this day, many are still struggling. So what the government did, what our friend Rishi Sunak in Parliament gave an effective allowance to commercial tenants that they could delay making their rent, which in turn commercial landlords could not enforce possession immediately. Effectively, what usually happens when a commercial landlord isn't paid his rent, he has what's called the right of forfeiture. What that means is that a commercial landlord can effectively walk in and change the locks. Go in the night.
For non-payment of rent.
For non-payment of rent. For other breaches of a lease, there's other remedies, but particularly where it's a commercial property which consists solely of commercial premises, not a residential part. Whereas commercial premises.
Just explain that, would you? Because what would be a mixed situation? Just give us an example so people understand.
So what you have, you have, if you imagine a high street, you have shops along the parade. A particular shop might just have the unit on street level, and that's it. So a commercial tenant, he or she comes in, that's the property which they occupy, that's what they pay the rent for. Under the terms of a lease, they have the benefit of occupying that property. On top of that, you'll see on most high streets, there's residential property. It could form part of the commercial property, so it may be just be another first floor, but it could also be a flat, for example. And some leases do provide for both the commercial and the residential part to be part and parcel of the same lease. Now, if that's the case, it's effectively a mixed use property. And there's different legislation which applies. It's not the same as where the lease consists of just a commercial property, where if a tenant fails to pay rent, then the landlord has the right, as long as the lease provides for it, which ordinarily will, the landlord has the right to effect forfeiture, which is walk in, terminate the lease, take back possession of the property. Usually that's done overnight with the use of bailiffs, and by the time the commercial tenant turns up in the morning, he or she finds out that the property is he or she no longer has access.
So tell us about your particular case, because you dealt with a case where one of your clients, a businessman, was literally left high and dry. Summarize it for us in the 5 minutes or so. Just go through the steps, what happened, what you did, and what the end result was for your client.
So, as I was saying, ordinarily, the landlord has a right to forfeiture. The government recognized that in the pandemic, many commercial tenants would be unable to pay their commercial rent. So what they did is they took away that right to forfeit under legislation, under the Coronavirus Act, until such time as was defined in the future. In this particular case, then, my particular client ran a restaurant cafe business. Landlord thought he'd be a bit smart and walked in and changed the locks. And like I said, ordinarily that right would have been there, but the Coronavirus Act gave my client the protection that a landlord could not effect forfeiture immediately. They'd have to wait what was known as a moratorium period until that period ended. And in this case, that's what the landlord did. My client then contacted me and enraged that my landlord's taken away my premises. I can't run my business. I can't do anything. And then what we had to do is seek what's called an immediate injunction to get permission from a court to allow my client access back in. Alhamdulillah, we were successful. The judge who heard the case had no qualms about recognizing the statutory restriction put on the landlord and granted my client re-entry. And on top of that, he granted an order for costs for the landlord to be liable to pay for my client's legal costs in bringing those proceedings.
Right. So in summary, where you are, and this protection, does it still apply at the moment? If people are watching or businessmen, are they still protected under the Coronavirus Act or Corona legislation?
It was initially the period from when the pandemic hit in March. It allowed it delayed forfeiture until June, end of June. It was then extended until the end of September, and then it was extended again until the end of December. And currently, it's still in play. So landlords have to be very careful before they decide to take any action, like our naughty landlord did.
Right. So if you're a landlord and you've got problems with a tenant, take legal advice before you end up. So I think in your case, the order for costs was for many thousands of pounds against the landlord, and all the landlord needed to do was to consult a competent solicitor, take advice, and he would have been told, look, do not do this because you are literally offering a checkbook to the solicitors on the other side, and you could have potentially have a claim for damages for loss of earnings even, because if there was interference with the business of the landlord. So clearly our client, the landlord, walked away very happy and gave you a glowing...
Sorry, our client, the tenant, walked away very happy. The landlord was probably not so happy.
Right, so it's our client, forgive me. So this is basically very simple advice. Again, the disclaimer is that if you're a landlord or a tenant, do take legal advice before you act upon anything of this nature, because very often the fine print, as they say, the devil is in the detail, and we are giving advice on a general guidance basis. This is not to be acted upon, and if you act upon this, and you make a mistake, we're not liable. It wouldn't be a legal live stream without a caveat or a disclaimer. Now, before I go on to my next guest, my colleague Rahil Latif, I've got a question. Saad, this is for you. In the current pandemic, can an employer sack you for going off sick on coronavirus-related illnesses, bearing in mind you are superseding the sickness allowances? So let's just I'll simplify the question, Saad. In the current climate, if you are calling in and saying, I'm sick because of coronavirus, I've tested positive, I'm displaying symptoms, can you be dismissed?
Well, I'll start off by saying that is a very tricky question to answer generally, because when we talk about sickness generally, it's always a question of degree and severity, causes.
Explain those things. Sorry, you're using terms which many people follow: degree, severity. So just simplify for us. Give us a couple of examples so as to illustrate the point.
Yeah, so, okay, fine. Now, look, at the end of the day, an employer has the right to dismiss somebody if they're not capable of doing the job. And that's where sickness comes in. So if the sickness affects the person so much that they're incapable of doing the job that they were employed to do, in fact, any job that the employer offers, then you can reach a point where it becomes fair to dismiss them. But before we do reach that point, there's lots of things to consider. So as an individual, if you are falling sick, and especially due to coronavirus and things like that, which are currently obviously very, very hot and very, very current, I would say, look, on erring on the side of caution, probably not. But if you do get an illness which is that bad that you can't get out of bed, for example, and it's going to be long term, unless it amounts to a disability, in which case disability discrimination laws come into play, then if you're incapable of doing the job, that you have to seriously consider that could be a consequence.
And in terms of if you as an employee, if you've got these sicknesses, wherever possible, obviously you must document it, make the relevant phone calls to your GP, to the NHS services, so that if you're required to corroborate or prove that you were in fact ill, you can do that rather than simply sending a text message and email, I'm not feeling well, because it's about what's plausible. Let's say the employer is not very understanding, or businesses are going through a hard time, and an employer may say, well, look, I can't cope, I need to get somebody to help me run my business, I'm literally on the breadline. Then if you want to have a valid case, you need to be able to establish that your employer was unreasonable and you should be believed, because ultimately a tribunal would have to look at the evidence and say, well, he's called up 111, he's asked for advice, had medicine delivered in the current climate, unless there are other ancillary factors, you're likely to be on good ground, aren't you? But if you've literally got no evidence, didn't call anybody, didn't make an appointment, didn't get medication, but I was so sick I couldn't come to work, likely not to be very plausible, right?
Yeah, I suppose that is one factor. I mean, you highlight one important thing as well in terms of telling your employer. It's always very, very important that every individual follows the sickness policy of their employer, especially if the policies are part of your own contract of employment. Because if you don't follow those policies, if you don't follow the terms of the contract that you've signed up, then alternatively, you could be in breach of that contract. That could also lead to further problems down the line.
Okay. I've got a follow-up question from that particular person. I'll come back to you shortly. I'm going to mark that up. If you're watching and you have any questions regarding employment or commercial landlord-tenant issues, or any of the question that's bugging you, the areas we cover, if I can find the banner to put up while I'm just going to go, before we go on to Rahil next. Sorry, that background doesn't help. Are broad there. I'll just actually put it in the corner here. Just 1 second. So while I'm doing that, my colleague Rahil Latif, who is a director and he's also a practice manager as well as being the head of the immigration department, will briefly tell us about the issue of asylum and refugee status. So Rahil, if you can just summarize how somebody can go about claiming refugee status in this country, and what are the typical sort of things that they need to prove to succeed in a claim for refugee status. Over to you, Rahil. Assalamu alaikum, good evening. Rahil, can you hear me? While we're trying to get hold of Rahil, we seem to have lost Rahil. Oh dear. Rahil, can you hear me? Right, so Saad, the question for you, while I'm trying to sort this out, is if you have to self-isolate, but you are fit to work, but due to somebody else having tested positive perhaps, and in the family, and you have to self-isolate, your advice from central government is stay at home, an employer screaming down the phone and saying, get to work, I need to do my job. Who do you listen to?
Yes, thank you for that question. Well, look, common sense has to prevail in some way. So when the advice clearly from the government is stay at home, and you're following that advice, it's very difficult, I think, for an employer to dismiss somebody. Remember, the advice to stay at home is only going to be for 10 days as well. We're not talking here about something which is minor or trivial. We're talking about something which is very, very important. There are very, very important public policy considerations at play as well, in terms of not only protecting yourself but protecting others as well. I would say generally speaking, and this is not specific to any particular case, but if you were at home self-isolating, it'd be very difficult for an employer to fairly dismiss you.
Okay, that's very useful. It wouldn't be a live stream without a technical problem. We can see Rahil, but we can't hear him. So I'm going to try and, if somebody can, we can't even see him either. That's even worse. So in terms of, coming back to you, Adnan, with regard to commercial and residential landlords, clearly businesses are struggling, landlords are struggling. It's a very bad situation for many out on the high street. What do you suggest to both landlords and tenants in circumstances like this? Clearly, obviously, the more disputes there are, the more money solicitors make. But of course, we want people to try and be able to continue their businesses. The economy is being absolutely decimated in many parts of the country. What would you suggest to try and help people to manage these disputes without having to go through and destroy commercial relationships?
It's a very good question. This whole the general slogan in this whole pandemic has been "We're all in this together," and I think if that was adopted by both commercial landlords and tenants, many of whom have adopted that approach,
Yeah.
then having negotiation, having constructive dialogue, then they can work through this. On the one side, you've got landlords who obviously require rent and are entitled to rent. It's their property. They're giving it out for the benefit of the tenant. And at the same time, the tenant is struggling to bring in an income because of lockdown measures. So as long as what I would urge is for both sides to have constructive dialogue. There's options open to a landlord, and a landlord can perhaps accept discounted rent or even defer the rent. Or a commercial tenant can also at the same time take advantage of many government loans and grants which they've offered to cover the shortfall in rent, so that both parties can benefit. But unless and until there is that dialogue between both parties, if there's no dialogue and one, is both parties take a black and white position, no, landlord says I want my rent no matter come what may, and a tenant just refuses to pay rent even where there are schemes available to them, then ultimately that relationship will fail. And yes,
Yeah.
it is the solicitors who will ultimately benefit in having to take matters through the court processes, which are both long-winded and extremely costly. So it's obviously in both parties' interests to open the door, have dialogue, come to a mutual understanding, and try, as I said at the beginning, we're in it together, so work through it.
Brilliant. I've got a question which I think all of us may need to contribute to. It's a very good question. How does Brexit affect the implementation of the Human Rights Act 1998 and more broadly the ECHR? Should we change the way we frame legal arguments now? Saad, if you can ponder over the employment aspect of the employment protection that the European legislation under the European treaties brought. With regard to the European Convention on Human Rights, it's got nothing to do with Brexit and the European Union. Britain's a member of the Council of Europe, and the European Convention, 1950 European Convention on Human Rights, is distinct and standalone. So until primary legislation is passed to repeal or modify what's known as the Human Rights Act 1998, which was brought in by the Labour government of the time, all of the protections that you have and the obligations that you are subject to under the Human Rights Act, which effectively brought the European Convention on Human Rights into domestic law. Before that, you had to go to Strasbourg, to the European Court of Human Rights, or formerly the Commission, to try and secure your rights. What the Human Rights Act did was effectively make the European Convention on Human Rights effective in domestic UK law. You could argue it in any court or public authority where your rights were being infringed. So there's no direct effect or impact on you as a citizen, which diminishes or undermines the European Convention on Human Rights, which was brought into UK law by the Human Rights Act. With regard to the employment protections, Saad, the Working Time Directive and so on, just summarize for our viewer, it's a very good question, how, if at all, on the 1st of January, or sorry, at 11 p.m. on the 31st of December, there was any change from the protections that we had under the European Union laws and directives.
Okay, thank you. Yeah, so, well, let me start off by saying that most of the employment laws in the UK are UK-based laws, okay, laws made by this government and previous governments. All of those will remain unchanged by Brexit because they were not impacted at all. You highlighted the Working Time Directive, and I'll bring up another set of EU laws, which were the 2P regulations, which, for those who don't know what 2P stands for, 2P is when you may your employer may sell the business to somebody else. They come in, they take over, and you keep your job. It was to do with the transfer of undertakings and the protection of the individual's employment in that situation. Those are the regulations and directives from EU law which were affected by Brexit, but affected insofar as effectively the government has agreed to just keep on following them for the time being until they make their own laws. So, I mean, in a nutshell, really, there's no real change at the moment.
And Adnan, perhaps you may want to offer comment on this. In terms of framing legal arguments in the courts, where post-Brexit, do you see any meaningful need to change anything? Unless the law changes, presumably not.
No, I don't believe there is. I mean, like you rightly pointed out, the European Convention of Human Rights itself was enshrined within UK domestic legislation under the Human Rights Act, and that still prevails. So those arguments are essentially still open for argument.
Okay, I've got another question from somebody. It's to do with employment. Can a contractor, self-employed contractor, who's making use of IR35, secure full employment rights, such as protection against unfair dismissal? Perhaps, if I can ask you to broaden it before you go to the specifics. So we know that agency workers and self-employed people who are working, like the Uber case, which went to the Supreme Court, didn't it, last year? In terms of self-employed people, first of all, Saad, can you just summarize how the revenue, the HMRC, assess things like whether you are self-employed or not? Because a lot of people think the label you put on it is definitive, but it's not like that, is it?
No, that's correct. There isn't really any one real factor which determines whether you're employed or self-employed, and the approach which the tribunals and courts look at is a holistic approach. So you're right. There have been a number of cases since the gig economy took off, because a number of individuals have been told that they're self-employed, and obviously as a self-employed person, you have no employment rights other than maybe those in your contract. And they challenge that on the basis saying that, no, actually, look at what I'm actually doing. Look at how I'm working. Look at my arrangements. In essence, I am an employee. You may label me as a person who's self-employed and with no rights, but I'm actually an employee, and therefore I do have rights. Now, those cases have had mixed success, if I could put it that way. Some people have been labeled or found to be employees. Some people have not been found to be employees. But it's not defined simply by your tax status. It's not defined simply by what you want to call yourself. It's not defined simply by the IR35 or who pays your tax and national insurance. It is a holistic approach, taking into account many, many factors. For example, practice of what you do on a daily basis. Who does what? Can you get somebody to replace what you do, to replace you if you're not there to do the work? Many things, many things.
Okay, in terms of contractors specifically, so people who work typically in the IT industry in the city, in the Docklands and places, who effectively have a company and they are contracting to a bank or a big organization, can they secure employment rights, full employment protection, such as protection against unfair dismissal? Specifically, the question being put is, could a contractor secure precedent? And I think perhaps what the questioner is asking is, if the contract is not renewed, because if it's terminated early, presumably the contract defines the remedy if it's not been followed, so there'll be a breach of contract claim. But let's say you get to the end of the contract, I go to knock on my managing director's door, say, look, boss, my contract's coming to an end, I want to renew it. Well, sorry, Bashar, I'm not going to renew it. And then they take somebody else on in the same role. Could I argue unfair dismissal or discrimination or anything like that?
Right. Well, look, if that contract makes it clear by taking into account many factors that that person is not an employee in any way, shape or form, then the only claim that person has if the contract comes to an end and it's not renewed is if there is a breach of contract, because that person cannot claim an unfair dismissal. You have to be an employee to claim unfair dismissal, and you have to have been employed for 2 years as well. Unless those two criteria apply.
Sorry, forgive me. I was going to ask you. So minimum 2 years of employment as an employee.
As an employee.
And the factors that you mentioned at the beginning about what determines employment, the label is irrelevant. Ultimately, an evaluation has to be made of your role, your duties, and whatever else may exist in terms of practice. So whether you are working through the means of a company or inside IR35, the anti-tax avoidance or legislation on the rules. Either way, the status of employee has to be established before you can get the protection against dismissal as an employee, correct?
That is correct, yes.
And then depending on, so unfair dismissal is 2 years. What should people be aware of with regard to religious discrimination, racial discrimination, or unlawful dismissal?
Yeah, okay. Now, discrimination is covered by a different set of laws, the Equality Act, which sets out that one person or a company cannot discriminate against another for various reasons, such as religion, race, disability, things like that, marital status. There's other characteristics there as well. Now, if anybody feels that they have been discriminated against by another person, they can always bring a claim against that person for a breach of the Equality Act. In the employment setting, that will normally be the employee making a claim against the employer, but the Equality Act is far more wide-ranging and applies to far more settings outside of the employee-employer relationship as well.
Okay, I'm going to go. Raheel is back with us, so we're going to have to move on to the issue of asylum, immigration today. Raheel, do you want to tell us about what somebody who's fleeing persecution from wherever in the world, who turns up at Dover or at Heathrow, what are the basic requirements to succeed on a claim for refugee status, and what sort of evidence do you need to provide to convince the Home Office or a court to do so?
Well, I hope you can hear me now. Is that okay?
Yeah, we can, loud and clear.
Okay, I've sorted that issue out. That's great. I think the main, what I was going to start with actually, because I was just thinking about, is just to highlight that in terms of the work that we've been doing here, we've done a lot of work for individuals who've claimed asylum from primarily the Middle East, as well as other areas of the world. And I think if you were to look at the work that we've done, we've got a number of successful cases that form the basis of country guidance cases, and I'm sure you could elaborate on that if necessary, particularly with Syria, or individuals Syria and Kuwaiti Badoons as well as other notable cases as well. In terms of what needs to be done by an individual, well, ideally, as soon as an individual decides that their life may be at risk or they have been persecuted in their country of origin, is that they should make a claim for asylum as soon as possible. That's a key requirement. There may be reasons why they may not be able to do that when they arrive in the UK for any particular reason, but as soon as they can do, they should do with the Home Office, or now with a specified location within the new rules which have come out. In terms of pursuing a claim for asylum, once they've gone through the initial process, then thereafter it comes down to the burden being upon them to prove their case and obtain the relevant documentation or information, ideally, to support their claims of having suffered persecution or their fears of potentially being victims of some form of persecution. And that can take various forms, from mere threats to actually physical harm that they've suffered. And within the Refugee Convention itself, there's various reasons an individual may have been persecuted or may suffer persecution, be it nationality, be it race, religion, or in terms of being part of a social group. So those are sort of general criteria which an individual can come forward with whatever evidence they have, and we can examine that and advise accordingly. We've had many individuals. If you take, for example, individuals from Kuwait who claim to be Badoon, or they say undocumented Badoon, they have no documents at all. And therefore, the issue is whether or not they're credible individuals. They can satisfy the Home Office that due to the experiences they've had, that they meet the relevant criteria from the information they provide. And hopefully they've been consistent with the evidence, which is quite important. And this is then considered by the Home Office. I think what are some of the recent issues that we faced for individuals is those who claim asylum prior to COVID, is the delay in the asylum system, and unfortunately COVID hasn't helped, and there have been significant delays with individuals, one, being interviewed, and secondly getting a decision on their claims. But I think the Home Office has slowly got that together, even during the pandemic, with getting private companies on board to try and interview individuals. There's a lot to be said about the Home Office decision-making system or process. That's criticised quite heavily, but thankfully there is right to appeal available if anyone needs to go through that route as well.
I mean, one often hears people running away from personal disputes. One can understand if you're fleeing a government. So if a government is out to harm you, lock you up, deprive you of your liberty, clearly there's nowhere to run. Whereas if that was Mr. Saeed's cat by the look of it, famous. There was a cat mentioned in an asylum case, wasn't there, not too long ago? Anyway, come back to where we are. The tabloid press will love it. Coming back to where we were, so if somebody is running away from a personal land dispute, they fall out with their partner or something, would that be something that you typically see in a claim for asylum? And if you did see it, what are the chances of something like that succeeding?
Well, it's not necessarily typical, but it's not uncommon. We've had individuals who have substantial debts owed to whether it's individuals or gangs in certain neighborhoods or areas, or there may be a family dispute. You just get some cases where there's forced marriage, for example. That's slightly separate. We can address that later. But in terms of land disputes, for example, you mentioned, wouldn't say it's impossible, but it depends on the facts of the case. It depends on the circumstances of the individual is, where they're from, what support networks there may be in terms of whether or not they can relocate within a particular region or area, the individuals or gang or group that they fear harm from, whether or not they have the means or capability to locate that individual if they were to relocate within their country of origin. So there are greater hurdles to cross or barriers to overcome, but it wouldn't be a total lost case, so to speak. It would depend on, again, on the facts, and that's the unique thing about asylum, that each case is more or less specific to its facts, and that's how it should be dealt with, and how the Home Office look at it as well.
In terms of if they're unsuccessful, we heard lots of things about the government's talking really, really tough about taking people. Well, they were talking about taking people out to remote islands in the middle of nowhere, following the Australian model and things like that. But none of that has thankfully come to fruition, if that's the right word.
Yeah.
When people are refused, you talked about a right of appeal. Can they normally remain in the UK for a right of appeal, to exercise the right of appeal, or do they have to leave the country?
Ordinarily, as long as the individual claim is not certified, and we'll discuss that later, but they would, being a first-time claimant, would have the right to appeal in the UK. There are exceptions that could apply in certain circumstances, and then it gets a bit more complicated. Okay.
And in terms of the court process at the moment, because of COVID, how are these sort of hearings taking place when people are refused? Because are people, for example, are your colleagues or required to attend court as solicitors, and are the people who have been refused required to turn up at a court somewhere in London or wherever else they might be, or are remote hearings taking place?
I think, well, prior to COVID, the courts were trialing or piloting online hearings, and with the advent of COVID, that's been accelerated to the extent now that all hearings are online, and the process has been modified, and will continue online unless there's a need for a oral hearing to take place. I mean, it's face-to-face hearing in the court itself. So we have an individual case where the individual, due to mental health issues, the online process is not suitable, and the court has agreed to a face-to-face hearing, although that's now been adjourned to be heard at a later date, and we'll see if that really does take place given the current circumstances.
It may be worth just adding, adding that the Lord Chief Justice, I think it was yesterday or the day before, who's the most senior judge in England, said basically, I think across all jurisdictions, the default should be a remote hearing by phone or by video link, and face-to-face should only take place where that cannot be done. So I think we'll see things moving more towards remote hearings across all jurisdictions.
And what do you guys think? Come to you, Adnan. It's a topical subject. I want you to think about that while I'll answer one of the questions. The idea, with online or telephone and video link hearing, if you compare them to face-to-face old school trial advocacy, as we used to have, you seen that yesterday, but I mean, it's become an exception that you actually see a court and see somebody in person, sort of digital images everywhere at the moment. Just ponder on that, how that is, excuse me, in terms of achieving the end result for a client. Does it make a difference? I've got a question which I'll deal with, which is, what would someone who, as a result of abuse from the authorities, such as the police, etc., who's suffering from post-traumatic stress disorder, PTSD, excuse me, what do they do if they're struggling to get legal aid or legally aided representation? Are there any organizations or even legally aided firms who we would be able to recommend for advice? The short answer is we wouldn't be able to recommend anyone. The difficulty at the moment is that many firms gave up doing legal aid work or parts of legal aid work because it wasn't profitable. I mean, legal aid has not really kept in pace with even inflation for decades, probably. So your story is not unique and you're not alone. Of course, there's a bar pro bono unit, there are law centers, there are possibly citizen advice bureau where you could potentially seek help. But equally, you just got to look for a specialist firm that has a legal aid contract in the area of law that you are in need of advice and assistance. So effectively, it will be a public law action if it's against a public authority, such as the police or any other local authority. If you are bringing a claim for physical abuse and post-traumatic stress disorder, that's potentially a claim in damages, possibly personal injury if it's physical, unreasonable use of force or unlawful use of force, then potentially it could be a civil action against the police, or you could possibly, I'm not a PI, personal injury specialist, now personal injury lawyers are not here with us today to tell us, possibly could be a personal injury claim. So you've got to, unfortunately, shop around on the internet, our friend Google or Bing or whichever search engine you use, to try and find a firm that may be able to assist you. But it is difficult, and you're right, it's not easy to find somebody. And then in terms of this online advocacy and online hearings, clearly when it's to do with administrative work, you must be relishing that, because there's no more trudging off to a court in the middle of nowhere, wasting a whole day, only to be told at 10 o'clock, so 2 o'clock in the afternoon, no judge, come back next time, or a 10-minute hearing and you're there the whole day. So that clearly is welcome.
Yeah, I think from an advocate's perspective, remote hearings are definitely welcome. Previously, you'd attend hearing, like you said, attend court at 10 in the morning, not to get on before a judge until about 4 or 5 p.m. And sometimes even then you get adjourned off. With the benefit of remote hearings, which I found, particularly in civil and family proceedings, is that a lot of hearings are being conducted by telephone, by BT Meet Me and other platforms. Some are being conducted by cloud video platform. And to date, since the start of the pandemic up until now, I found that they work like a charm. I found that the judges who I've engaged with during those hearings have been able to get to the point quite quickly, because you're on the telephone as well. People don't generally interrupt each other either, like they would in a normal open court. But yeah, I think they've been working very, very well. Directions hearing, especially if the court his role is just to give directions for case management, whatever, then they work brilliantly. Even as far as trials are concerned, I believe there was a case, I think it was in the High Court, where there was a 12-day, I think it was in the Crown Court, there was a 12-day trial, which was done purely by video, where they had a number of witnesses and a jury, and it worked without, well, there would have been some technical problems, I'm sure, but it worked successfully. The only downside is that seeing somebody on a video screen when you're trying to cross-examine them is not the same as having them in front of you, where you'll be able to assess their demeanor and so forth. But again, it's not a problem. We conducted a hearing in the London International Arbitration Tribunal, where one of the witnesses was in LA. And,
Los Angeles in America.
In Los Angeles, yes. And it was, apart from having the benefit of seeing the sun rise behind him, which was absolutely amazing, it worked fine. The cross-examination was conducted, wasn't a problem. I think
we're going to talk arbitration. Next week, I think you're going to talk about arbitration, perhaps, because that's a fascinating subject for litigation, where if it's part of a contract where it's mandatory, how that works. So you're finding overall a lot more benefit in telephone and video link hearings, but that sort of face-to-face cross-examination, chemistry, it's not there, and that's something which is missing. But that's quite fascinating that a jury trial, so it must have been a serious offence, a Crown Court trial, a 12-day hearing was conducted entirely by way of technology. So there are benefits to this. So the employment question within IR35, so someone is a contractor, they're invoicing, I'm assuming, and if our viewer is watching, please come back to me by all means. So they're within what's called IR35, so they're self-employed and they're a contractor. Can they get protection against unfair dismissal? So the question, if you go through a structured basis of where unfair dismissal applies, because if you are self-employed, albeit within a scheme, that's a tricky one. I mean, if you're not sure, you can potentially, if I'll ask an email to be put up to me, and maybe we can respond afterwards. But if you do not know the answer, that would be useful. So it's a specific question within the scheme known as IR35, a contractor, so self-employed within IR35, would they have protection specifically, not as a company, as an individual, against unfair dismissal?
Yeah, I think I thought I'd answered this before, but quite simply, no. If the person is self-employed, they have no right to unfair dismissal. The right to be unfairly dismissed only applies to
not to be unfairly dismissed, you mean?
Yes, the right not to be unfairly dismissed only applies to an employee. So you have to be an employee.
Okay, so the critical test there will be to our viewer is, if you are an employee, do you get a paid holiday? Are you getting a pension? Are you answering to a manager? Do you determine your own work timings? All of the things that you mentioned, which would be used to evaluate whether or not somebody is, as a matter of fact, an employee, rather than being a person providing their hired to give service rather than employed to do the work. So effectively, it's a question of fact, i.e., if you were not offered a renewal of your contract, I assume that's where this is going, and you say, well, look, for all intents and purposes, I'm an employee and I want my contract renewed unless it's redundant. And if you don't renew it, I'm going to take proceedings against you. So I think would you advise the viewer to actually raise that at that point? But then I suppose you can't have your cake and eat it, because if you're taking the benefits of self-employment, the employer may well say, this is very disingenuous because you came in on a self-employed basis. You want your cake, you want to eat it, and you want us to feed you the cake. I mean, that's, again, I'm no employment lawyer, but that's what it would potentially seem to be, to come across as.
Yeah, I think you make a good, valid point there. But I think, look, for the person posing this question about the IR35, I'll say two things. It seems to me, it appears to me as though he is calling himself a self-employed person. And if he is correct about that, then, like I said, he's got no right for unfair dismissal because he's not an employee. But really, what he should do is seek legal advice about what his actual employment status is likely to be. Remember, there's always a scale. There are people who are clearly employees. There are people who are clearly self-employed. And there are those in the middle. Okay, and a lot of the people who are in the middle, the cases we hear about nowadays are those in the gig economy. And it's through no fault of their own. But if you think you are somewhere in the middle and you're not sure, it's very, very important to seek legal advice before you decide if you can do anything and what to do next.
And for those of you who are watching, I mean, by all means, please email us topics, subject areas, burning issues that you would want us to cover in the coming weeks. This is our first live transmission with the team. We did a test transmission on the weekend. So what we'll be doing is every Monday, we'll be joining you, and you'll be hopefully joining us. Spread the word to others who may benefit. And whatever questions or comments you have, by all means, put them through on the posts we have here. You could go to our website, www.amansolicitors.com, and email any of the solicitors who are on the live stream, myself or my colleagues. And we will happily even think to prepare. So if there are questions whether to do with education, I mean, one of the subject areas we will look at potentially next week is educational law and students at universities, at colleges who are suffering. It's something potentially very big. We need to be looking at that. Before we conclude, just one final question, but then perhaps this is something for you. If one is attending to conduct a JR application against a public body, such as CAFCAS, for refusal to make a policy provision to safeguard a minor from misrepresentation by not recording the appointment. So I think what the questioner is saying is, when the minor was being assessed, I'm assuming that he asked, it must be his child, or who was being interviewed for the purpose of CAFCAS, for those that don't know, is the body that assesses whether or not a child should have contact and what contact they should have with the parent. So if you can have a quick look at that, Adnan, in terms of the trigger here is, if I will assume this parent asked CAFCAS to record the appointment, audio or video, they refused to do so. What is he going to have to establish? I mean, I'll deal with the judicial review part, and perhaps you can deal with the CAFCAS part. But look, judicial review is a review jurisdiction. It's not an appeal. So what you would have to show as a person attending is that the public body made a public law error. They did not follow the published policy. They were biased or prejudiced. They behaved in such an outrageous or unreasonable behavior that no reasonable person in that person's seat could have made that decision. It's not another person would have been more sympathetic, or they should have looked at this in a particular way. No, the way these things work is very straightforward. It's a review jurisdiction, and once the review, for you to succeed, you must show that the process of decision making was incorrect, such that it may have made a difference to the outcome, or they didn't follow the law, or they, to use a crass example, all blokes are terrible fathers. You shouldn't meet your children, a lousy piece of work. Or conversely, all women are X, Y, and Z. I mean, I'm giving a bizarre example. That will be clearly unlawful on many counts. That's the public law element. But with regard to CAFCAS and how they should perform their duty, Adnan, perhaps if you would share a few thoughts with us.
Okay. Well, you're quite rightly pointing out, CAFCAS it's a family court advisory body. Its primary role is to advise the court in child-related matters. The judges are not necessarily trained in assessing the best interests of a child. That's what CAFCAS is there for, to provide that advisory service to the court. It has certain guidelines which it must follow. It has it has legislation which it must follow. Section 1 of the Children Act specifies what are the factors that need to be looked at when assessing a child's welfare. And these within family court proceedings, especially child proceedings, are extremely important for CAFCAS to assess a child's welfare, form an assessment, and then provide recommendations to the court. CAFCAS is not a legislative body. It is not there to pass legislation. It is not there to make findings of fact or give any rulings on anything. Its pure role is to give advice. Now, in this particular case, if it was, we don't know the full facts, but if it was the case that the judge had directed for CAFCAS to record the appointment together with the child, and there was a failing in this part, then there's the appropriate remedy would be to that very same court or judge who made that direction. But quite right, how you pointed out is if there is some public policy which requires for it to, in certain settings, to record an appointment with a child, and it failed to do so, then there may well be a possible scope for a judicial review challenge.
I think what you raised, thank you very much for that. The point you raised is that good, experienced advice before you start a process is very important, because if in this case I suspect there is some suspicion of undue influence from the parent that is in custody of the child, i.e. influencing them as to what to say about the parent that's seeking contact, then you need to come up front. You must, rather like your doctor, you need to share what is relevant for the purpose of the case, rather than personal hatred of each other, you and not liking your former partner or spouse, whatever it might be. But anything that you think is relevant, which your solicitor should know, because as you have identified as an absolutely critical point, that you would want the judge to make the order, to direct CAFCAS I want you to record it. And I'm assuming you would have to give cogent evidence why you want to put them through the extra expense and the burden by putting before the judge whatever you say supports your application for what's effectively not an exceptional measure, but an unusual measure, correct?
Yes. What, interviewing a child?
Yeah.
Recording an appointment.
Recording
It is unusual. It's not commonly heard of. Kafkas will conduct an interview. They may well have a written interview record for their own benefit, which they then refer to in their preparation of any report where they provide recommendations to the court. It's not common. But it all depends on the circumstances of the case. It may be that the particular case warranted for there to be a recording, because there may well be, as you've quite rightly said, an element where the other parent in whose custody the child is perhaps unduly influencing the child, which is making him or her say things which they don't intend to say. And it's only if there is, perhaps recording that can be ascertained. I mean, one thing to also point out is that if there is the case that a child is being unduly influenced, then under the family procedure rules, it's actually rule 16.4, the court has the power to appoint a guardian who will represent that child within those child proceedings. And that may be the appropriate safeguarding mechanism to ensure that a child's full wishes and feelings are represented in court.
Excellent. I think, again, what this brings to light is going to somebody who's competent and qualified, because common sense, as the average layperson may think, is not how it translates into the nitty-gritty of this process, because the court is dependent on assessments and advice that is given by Kafkas. Of course, the court can overrule, and I'm sure you can cross-examine Kafkas officers, i.e. challenging them in a court if you're not happy, but you have to have a proper evidential basis. The final question, I'll answer there's a clarification. Short answer to this clarification by the same viewer is that if the judges refuse to order the interview to be recorded, then you either challenge the judge's refusal to order that by appealing or possibly judicially reviewing. I'm not sure what the remedy would be if a county court judge, a family court judge refuses to order, or even a magistrate's court, perhaps. Some of the family proceedings take place in that jurisdiction too, right? So if the judge or the justices refuse to order the interview record and you believe it's unlawful, you have to satisfy the test of illegality rather than preference, then you will need to take legal advice on either an appeal or a judicial review against that decision. With regard to what happens in Wales, the viewer has asked about what happens in PACE interviews in the police. Different jurisdiction. Under PACE, there's statutory codes of conduct in place, and the police, as a matter of routine, because of scandals back in the 70s where manufacturing and fabricating of evidence, particularly in high-profile trials, was exposed later on, resulted in miscarriage of justice, for example. Different jurisdiction, different interest, therefore you cannot make that comparison. One final question, and we'll end on this one, and I'll answer this one. The question is to do with land in Pakistan. Our parents and grandparents who came here once upon a time, long time ago, now that they're getting elderly, they've got assets over there, what advice would we give? Short answer is we don't advise on the law of other than England and Wales, so this is not legal advice, but it's practical advice. Those parents should identify the assets, provide and tell their children and relatives where they are, appoint competent people to manage and, if necessary, sell that land, because the problem you will have is if people don't know what the land consists of, where it is, or any property for that matter in another jurisdiction, and very often with regret, or many second generation people don't speak Urdu or Punjabi, Patwari, whatever, Pashto, let alone read and write Urdu, and hence further problems, although of course the legal system of Pakistan is in English, but everything is said and done pretty much in a different language. So those parents need to identify, take their children out there, this is your house, this is this, and my advice would be transfer it onto your children's name in your lifetime if you want to, but take legal advice. This is not legal advice, but practical advice, because that way they won't have to go and fight a cousin or an uncle who's decided that it's mine because I say it's mine, not because I'm entitled to it, which is a regrettable scenario for many, many people that I know. Thank you very much for...
Sorry,
Of course.
can I just add to that? It's also worth
Please.
considering in that scenario the importance of having a will.
Very good point.
Because that would help to safeguard assets, whether they're in the UK or abroad. Obviously, in countries like Pakistan, it has its own laws related to inheritance. But having a will, and possibly during your lifetime, making sure you have powers of attorney in place where you leave
Excellent.
that responsibility to somebody who is trustworthy, and that's one way of safeguarding assets.
Brilliant. Well, just before we conclude, I want to say one more time, all advice that's been given on this program is for guidance purposes only. Please do not act upon this advice and carry out anything that you're doing in the course or advise others to do so. You must get professional legal advice from somebody who is competent to give it, and then act upon or get them to act on your behalf, because just as you wouldn't pull out your tooth based upon what a dentist says on television or operate on yourself, equally, the law is very precarious, and we're not trying to drum up business. You just need to take up professional advice from somebody who's an expert in their field, so that whatever you wish to do or prevent being done is done in a proper way, so as to secure the best possible outcome for you in the least amount of cost, with the least amount of pain, and the quickest possible route. Or for all it remains for me to say is to say thank you very much to my colleagues, starting with the top right, Saad Saeed, Adnan Mahmood, and Rahil Latif, who has some technical difficulties. We won't have that next week, hopefully, but it wouldn't be a live stream without such things. Thank you very much. Jazakumullah khair. It was an excellent session. I thoroughly enjoyed it. I hope the viewers did. And for next week, please share the links, share your comments with us by way of email, by way of Facebook comments, share, like, comment, and whatever else you want to talk about. If you go to our website, you will see the areas of law we deal with, and we may well even dabble in something we're not specialists in. These are our specialist fields. By all means, send us an email, send us a message, so myself and my colleagues, we can do some swatting up and hopefully be of help to you all again. In the meantime, please stay safe wherever you are. Look after yourself. We are living in very testing times. Until next time, Assalamu alaikum, goodbye, and all the best. Assalamu alaikum all.
Islam.
Well, thank you very much. And we're going off air.